The New York Times dropping this absolute bombshell news that Donald Trump is, quote, likely to be indicted in New York. Well, tonight, Trump's lawyers acknowledge a key point in that account, that the DA has indeed invited Donald Trump to testify to the grand jury. And this isn't hypothetical. This isn't someday. This is next week. An invite to testify next week, according to two Trump lawyers. Now, they are in Florida over the weekend. They're discussing strategy. They're taking this as a real thing. Seriously, they tell NBC News. However, they have no plans to meet with the Manhattan DA, Mr. Bragg. So let's get some clarity up top. There are many stories we cover where we say, here's this thing, and then here are people involved. Could be people in the Trump or the Biden administration, but they say, well, that's not the whole story, or we disagree. This isn't that kind of story right now tonight. I could tell you there's no public debate about the escalation. You don't just casually suggest a former president should pop down and tell the grand jurors stories about hush money payments. This isn't some campaign documentary. This isn't some Howard Stern interview. This is a criminal grand jury. And tonight, Trump's lawyers confirm and agree and don't deny that they have been furnished with this invite for Trump to do that next week. Now, New York DA Alvin Bragg is, we believe, only doing this as one of the last steps before what the Times calls a likely indictment. Now, in one of his few TV interviews since taking office, Bragg did tell us that his approach to the Trump probe was still open, and he cautioned at the time against reading into any developments in one particular case.
The investigation's ongoing. This is one chapter. I caution people against reading ahead.
Okay. Well, that was then, and the DA appears to be in a new chapter right now. Legally, Trump could address this grand jury, but strategically, everyone will advise him not to go in. That's how a Trump aide put it. The former president is already mounting a public defense, casting the payment as actually a criminal plot by the person he paid. He calls it, quote, extortion, and attacks this probe as corrupt, depraved, and weaponizing the justice system. Now, let me tell you this. As a potential defendant, Donald Trump has every right to mount those defenses and counterattacks, whether that's in public or in court if it comes to that. And while Donald Trump does lie a lot, that has been established and reported out through all the fact checks we've seen on many topics, and while Donald Trump has made frivolous arguments in court, including many frivolous losing cases after he lost the presidential race, as a legal matter, some of Trump's current defenses are potentially valid. They are not what in the law we would call frivolous, like beneath discussion. Trump's lawyers can make the argument that the legal road to this 2016 campaign spending offense is sketchy, that the New York DA's office recently had a prosecutor in a related probe leave in a clash and then publicly call for Trump's indictment. They can make those and other challenges to the process. And I'll get into that here a little bit more tonight. On the other hand, these prosecutors looking at potentially indicting Trump have evidence and the literal receipts, with Trump's signature on the check, which is a type of receipt that he paid to Michael Cohen for what was then the secret payments. Now, Cohen memorably did hard time for several federal offenses, and we know he spoke to these New York investigators repeatedly and to the DA recently, who has brought in a slew of witnesses, including one who popped up in the Mueller probe, that National Enquirer vet who actually brokered the deal with Stormy Daniels. Another one was Trump confidant Hope Hicks, also facing this DA, and Kellyanne Conway, who helped run the Trump campaign at the critical time of these payments that are still clearly under review. Now, those look like people who could speak to the payments. But the DA also has a separate case that convicted the entire Trump organization on the business side, not the campaign side. Its CFO, now behind bars on Rikers Island. So it was possible that the DA was looking at other leads linking money or political plots. It was after the Trump org conviction I mentioned that Bragg actually joined us here on the beat. I showed you a little bit of that. I want to show it in context because we asked him about criminal liability for Trump himself. Why does it not lead to charging Donald Trump himself?
So, as I said back in April in a statement, the investigation's ongoing. This is one chapter. I cautioned people against reading ahead. We needed to focus on this and do what I thought the public servants in my office, a superb job they did in the courtroom. That was the focus. But as I said, the investigation's ongoing.
That was December. That was recent, ongoing. Now, there are words, and then there are the more nuanced and wider strategies and technical items. So let me put it like this, because everything just seemed to change last night, and we're just following it with you. But things can technically be ongoing, but also winding down. The 2016 payments are not the most serious criminal liability that Trump has, or the second most serious, or even really the third. Quite frankly, when Bragg said that it was ongoing, it did not at the time strike many legal experts as a sign that it was headed towards, this ongoing probe would be barreling towards new headlines about a likely indictment. So suddenly here we are, and things look very different. Now, as mentioned, there was that other prosecutor hired to probe Trump by this DA's predecessor. And he recently went public with his gripes about not getting clearance to indict Trump. He also impugned the current DA, Alvin Bragg, on many points, including the idea that allegedly Bragg had suspended indefinitely the Trump investigation, which is not what it looks like right now, depending on how you define it. But if Donald Trump is invited to the grand jury and then charged, well, this thing ain't all that suspended. Now, when Pomerantz joined us right here on The Beat, he was basically publicly campaigning for a Trump indictment. And he was walking right up to the legal line of what an ex-prosecutor is allowed to do. And I pressed him on whether he simply didn't have the goods, whether on the part he was working on, which was a lot more about appraisals and real estate values, although it may have overlapped with some of this. And as I've always mentioned, there's no way to fully prove that because so much of the grand jury process is supposed to be and does stay secret. So I pressed him on whether he just didn't build a strong enough case and why he should be the one to decide the public interest. Is it possible that all those people were essentially right and that you didn't have the case ready?
Look, the mini revolt, first of all, was on the issue of timing, not on the issue of substance.
Yep. You talk about leaks when you were on the job. You say, for example, press attention was an obstacle to getting things done as a prosecutor. You are the one leaking in detail about this case while there's other stuff going on. Is that fair? Is this a good model, in your view, for justice in America?
Sure. Let me speak to that. First of all, I want to make it clear that when I was a prosecutor, I never spoke to the press. Period. I resigned. Now I'm John Q. Public. I'm a citizen. I don't speak with the authority of the state behind me.
And you decide that as an ex-prosecutor, what the public interest is.
I made the judgment that it was in the public interest.
That's a veteran of the DA's office. Now, Trump's lawyers can try to use some of that to tar any potential charges if they come, just as they can validly make the argument that as a finance and campaign spending case, they'll argue this is a reach. If Trump was trying to pay for silence as a person, as a civilian, and the remaining offenses boil down to what they would call accounting debates. And Donald Trump has certainly ducked other legal accountability with complex accounting. Now, this is a big deal. We're here gathered at a time where many people might say, hey, Ari, I don't need the update. I don't need the road. If there are charges, tell me. Otherwise, I'll believe it when I see it. And that's fine. It's a free country. You don't have to follow every step of this. But in journalism, we do. You saw me press one of the DA's vets there. You saw me talk to the DA himself. We've been covering all of this. And so in context, I want to share with you, if you're interested in sort of trying to keep our arms and minds around what kind of case this is, on this program, we've broken down other big cases in the Trump era, like how strong those conspiracy cases were against the January 6th attackers, and how there are slam dunk cases against Trump figures for impeding an official proceeding on January 6th. The first bucket of those cases, including sedition cases, they've been tried and won. I mean, they've ended in convictions. The second bucket, whether people like Mr. Eastman or Mr. Meadows will ever be charged for impeding a proceeding, only the DOJ and Jack Smith know the answer to that. But I'm telling you, both those buckets legally are strong cases. Now, is this New York case against Trump, is it as strong as those? No. It is a novel case. In some ways, it's dated, and it has that complexity I mentioned. So that could ultimately inform hesitance inside the DA's office over whether to even bring it. Now, if no person is above the law, and this is not the strongest case ever compared to other related issues in the Trump orbit, The other question is it a decent case? Is it winnable? Do people really get in trouble or go to jail for this kind of offense? Well, tonight, one way to answer that is ask Michael Cohen. He already did. And so a lot has happened. You'd be forgiven for having all of our different legal scandal memories get a little fuzzy these days. Mr. Cohen didn't just go to prison for this type of offense or a precedent of something like this. Mr. Cohen went to prison in America, we all lived through it, for this exact very payment for Donald Trump's benefit by Donald Trump because he ultimately provided the funds. And he went to jail in the federal system for that. Now, at that time, under the rules, whether you like them or not, the rules officially barred federal prosecution of a sitting president. So that's where that case ended. But if lawyers like precedents, that precedent is so on point, Donald Trump has his own legal nickname from that conviction, what I mentioned, Individual 1. Whether Individual 1 moves from a old school nickname to a new term, defendant, in the case of the people of New York versus Donald Trump, well, as of this hour, that's something only the New York DA knows. Just as only he knows why he took this unprecedented step of offering Donald Trump the chance to face this criminal grand jury next week, which Trump's lawyers do not even dispute.